Commonwealth versus Canyon.
Thank you. Fine. Yeah, thank goodness.
Thank you.
Mr. Cohan?
Good morning. It please the Court, Dana Curhan for Tyran Daniels. With me is Brad Benyon. His role here this morning will be to kick me if I start talking about the wrong case.
I understand that you've already had one appellate argument this morning,
Yes.
and we can also help you if you...
Thank you. The defendant contends that he's entitled to discovery and a hearing on his new trial motion and ultimately to a new trial where the Commonwealth withheld exculpatory evidence that would have materially aided the defense. The victim in this case, Ian Pitter, also known as Buju, was shot and killed during a home invasion and a robbery perpetrated by two masked men and one unmasked man. The investigation initially focused on a number of potential suspects. Wanda Brady, the victim's girlfriend, identified Wayne Rowe, also known as Color, as the only person who might have had a problem with Buju. She made a statement to the police shortly after the killing. However, the government ultimately focused on someone named James Brown as the gunman based on a fingerprint that was found in the apartment. Now, upon learning of Brown's identity, Brady asked her husband, who hangs out with Brown, asked him who is a friend or who hangs out with Brown and who does he know. And the cousin mentioned the defendant. And she realized at that point that the defendant was somebody who was familiar with her. She had gone to school with him. I guess her cousin had a child with him, and she started focusing in on him as the unmasked man.
Mr. Julian Thompson,
Yes,
do we know where he is?
he's dead.
Okay.
What ended up happening is based on the Commonwealth immediately started focusing on the defendant and on Brown as the person who committed this killing, and pretty much decided not to pursue these other leads, or for whatever reason. Shortly,
Well, excuse me, wasn't there, didn't she identify him?
She
He's
did.
as the unmasked person?
she eventually did. Wasn't immediate. Didn't happen immediately. I think it happened a few months later. She said, "This is the third guy," and she identified him.
And the description that she gave at the time, I mean, what's curious about this, and of course you point this up rather well, is that here she is, she sees this person, describes them to the police, doesn't remember or describe him as someone that she knows and went to school with and had a child with her cousin, something. None of that is, that's obviously either she doesn't remember that at the time she gives this description, or maybe that is a memory prompted only later on. But the description that she gave to the police at the time, that right after she saw this person, right after the killing, how consistent was that with the person she ultimately identified, the defendant?
I'm not sure. I'm not sure if there's anything in the record indicating how consistent it was.
We have...
Said he had a big nose. She said he was bright-skinned. I think that's what she said.
Yeah, I mean, it's a description that would
I
fit.
guess that's subjective, isn't it?
It is. I think it's a description that would fit an awful lot of people.
The trial judge said a distinctive nose, and that brought to mind French actors or Pinocchio. I mean, I don't, a large nose, if that's, what was the evidence? Is Justice Island's memory correct?
Well, I don't think it was a Pinocchio nose.
When the trial judge said distinctive, I didn't know what a large nose is not distinctive.
I don't know what that means either.
Well, I'm asking you what the evidence of Brady was.
I don't think there was a lot of evidence on the subject. I think
Okay.
there may have been talk about a distinctive nose, and since we weren't at trial, I'm not sure if we can make that assessment.
Mr. Cohan, I don't want to throw you off track, but I asked you that I got the names mixed up. I really wanted to know where is Delroy Williams?
I don't know where Delroy Williams is.
Okay.
And Williams is the person who gave the statement that word is that Thompson did it.
Yes.
And we have no affidavit from him then?
No, we don't. No, we don't.
And what about the fact that even if we were to take his statement as true without an affidavit, the argument and the finding by the trial judge that it's not exculpatory because it doesn't address the defendant's role in the crime?
Well, I think it does because the identification. This was an identification case. The identification of the defendant.
Comes through Brady, right?
I'm sorry?
Comes through Brady.
Through Brady.
And Brady is told it's Brown.
That's
and
right.
she sits around, Brown's masked, or if it's Thompson, he's masked. The Commonwealth has said it's Brown, based on a fingerprint, and then she sits around trying to think of people who know Brown. Presumably, if it had been Thompson, she might have been sitting around thinking about who might have known Thompson.
That's right.
That's your theory, correct?
That's my theory.
And so it is, in fact, exculpatory.
It is.
Were
in fact,
Thompson and Brown friendly, or?
We don't know.
Yeah.
Thompson and Brown. We don't know. There's nothing in the record.
But Thompson and Rowe were friendly. Indeed, they held up places together. Is that the,
That's right.
the story?
So they could have
the
been
point.
two.
And Rowe was the one who had the beef with the victim.
That's right. It's. I mean, I think the statement, the Williams statement, actually contains three key points. I mean, the first is people say that Julian Thompson killed Pitter. Okay, that obviously is secondhand, and probably somebody should talk to Washington and find out who he heard it from, and that may lead to some additional leads. But what he also
Well, why
said,
wasn't that done for purposes of this, for the motion for new trial?
well, the motion for new trial was denied, and the motion for discovery was denied. I think the judge thought very little of this. That would have been the next step had we been granted a hearing.
Just for clarity, whoever this unmasked person was, they were not the person who did the shooting,
That's right.
right?
That's right.
Okay.
So Williams says, people say that Julian Thompson was the shooter. But he also said that Rowe and Thompson acted together robbing people for cash and drugs. He doesn't say he heard that, he says that. And he does make a few statements that he knew these people and presumably would know this may very well have known this firsthand. And he also said that Rowe and Pitter had been friends until 4 or 5 months before Pitter's death, and that their falling out was because Rowe claimed that Pitter had people rob him at his house. So there's perfect motivation for Rowe and Thompson to be committing this home invasion, this particular crime, and I think the judge acknowledged that. And again, that wasn't necessarily, we don't know if that was secondhand, but he doesn't say, I heard that this took place. He says it.
Now, remind me again when this interview took place. Did this interview take place after the defendant was indicted or just before?
It was after the defendant was indicted.
It was after the defendant was indicted. It was after the defendant had asked for information from the very murder for which
That's right.
Williams was being interviewed, correct? In other words, there had already been a determination, I want certain things from that investigation. Judge says you can have the ballistics, as I recall, correct?
That's right.
And the question I wanted to ask you, Mr. Cohan, is does the Commonwealth then have some kind of ongoing obligation if let's assume that this is exculpatory, but it wasn't available at the time that the defendant filed the motion, correct?
Correct.
Does the Commonwealth have an ongoing obligation? This is not just anywhere out in the universe. This defendant has said, please give me anything, presumably including exculpatory material, from this, what appears to be similar case. So now I've got two assistant DAs, or maybe the same DA, knowing that I've got defense counsel who's interested in what's going on in the second case, does the Commonwealth have an ongoing obligation?
Yes, I think the federal cases talk about an ongoing obligation to turn over exculpatory evidence. This statement was made 1 week after the judge denied the defendant's motion. And the Commonwealth never disclosed this statement. The defendant got it from Thompson's lawyer after Thompson's death. And it fit precisely within the defense theory. I mean, the defense counsel looked at Wanda Brady's statement and said, I think there's something here. I think there's something, I want to look at what's here.
Yes,
And
because it seems to be the case that she, notwithstanding, she saw the person for quite a short period of time, but he was unmasked.
Yes.
There's no question. And she seemed to have known him relatively well. She didn't identify him until somebody said, well, actually, the killer is Brown, so let's think about who we might know who was in Brown's circle.
That's right. And the two interesting points about the trial, there was a very good defense witness, expert witness called, who talked about the difficulties and the problems and the pitfalls with identifications. They're probably the best witness I've ever seen on identifications. The second interesting thing is that...
What's the name of the witness, Mr. Kelly?
I don't remember. I'm sorry. I'm terrible with names. Dr. Yarmy. Thank you.
Thank you, Ms. Montoya.
He was very good. And the other key point is that it took the jury
3 days.
3 days to convict him.
4-day trial?
Something like
3-day or
something like
4-day trial?
Not a long trial, not a complicated trial, but the key was identification. And had the defense tried to present this
How are we going to
theory.
get this evidence in?
I'm sorry?
Assuming that you don't have Mr. Williams, how do you get the evidence in?
Well, I'm not sure.
So let's assume I agree with you, there's a new trial, and now you want to give the jury some evidence. What are you going to give?
Well, I think what you're going to do is you're going to interview Williams, and you're going to see what, and also, I don't know what's in the Commonwealth's files. I think we take a good look at what's in the Commonwealth's files and see if there's anything else that
In the second murder.
The Roe murder.
right in the Roe murder, and that's really what we're looking for. We're looking for an evidentiary hearing, and we're looking for discovery. And ultimately, we may be looking for funds for an investigator to go out and talk to some people. And I think there's a very real possibility that something exculpatory can be presented. Now, there may be a basis for getting some of this in, where it's not an affidavit. It is a statement made to two police officers. It is signed. There is some indicia of reliability. I mean, I think the Commonwealth, if they wanted to get a search warrant for some reason, could probably take this and say, we have a signed statement from this guy, and he says the following, and get an affidavit on this basis. So there's at least some basis for saying that this is reliable.
Was Williams' statement, was Williams a suspect in the Roe murder at the time he made that statement?
I don't think so. I think he was arrested by DEA agents for something else.
Okay.
And he was
trying to give as much information as he could.
That's right.
To the police. I mean, which is fine.
That's right. And
clearly, whether in those circumstances you give false information or accurate information.
Well, hopefully you give accurate information if you want that information to do you any good. But I think certainly it warrants some follow-up, and I think. Based on this information, I don't think we get a new trial. But I think what we do get is a hearing on a motion for new trial, and I think we get discovery.
Well, you don't want a hearing before you get discovery, I assume.
Obviously, we want discovery and we want a hearing. And the Commonwealth does focus on the fact that we haven't made out a prima facie case for relief. I suggest, and I actually suggested that in the Tague case, that may actually be higher than the federal standards, where we just have to show a reasonable probability that the evidence would have been, that the result of the trial would have been different. I mean, I think the Tague case may have set too high a standard as a threshold for obtaining discovery, higher than what the federal cases have said as a required showing. So what I would ask is that this Court take a look at this issue. Illinois versus Gates says that a prima facie standard is higher than a reasonable than a probability standard, and I'd ask that the federal standards be followed at a minimum. But in any event, we do think that this would have made a substantial difference in the outcome of this case.
Well, if you could have developed some,
if we could have developed
some admissible evidence.
And there's certainly grounds to believe that something would have been, we would have been able to develop something. And certainly that should be explored at an evidentiary hearing and through further discovery, and that's what we're asking for. As far as the remaining points, I will leave those to the brief. We make an argument under 278-33E. I know that this was a very close case, and I would ask the Court to consider either a reduction or setting aside the verdict on that basis.
Thank you,
Thank
Mr.
you.
Cohen.
Thank
Ms. Montori?
Good morning, Your Honors. May it please the Court, Jane Montori, representing the Commonwealth in this matter. We're here today on a single sentence in a statement, not an affidavit, a statement.
A signed statement taken by the police. That's about as good as it gets.
Well, Rule 30, Your Honor, talks about an affidavit.
Well, how do we get an affidavit here? The whole point of the matter is the Commonwealth kept this under wraps, maybe not intentionally. I'm not suggesting blame here. For a long period of time, after the defendant's conviction, he comes upon him. He's supposed to now get an affidavit from somebody who's now disappeared. I mean, this is part of the problem here.
How can he do that if he doesn't have funds?
Well, I don't believe he asked for funds, Your Honor. He asked for discovery. I looked through the docket, and
what's
I don't
wrong with
see a
discovery
request
here?
for
What's
funds.
wrong with discovery here? This man's life is at stake.
There's-
He's in jail for the rest of his life. There's something here that suggests a lead. I assume the police followed up, but maybe they didn't. They
Well-
already had indicted their people.
They, let me go through a couple of things here. First of all, he said, people say Julian Thompson was the shooter. Well,
Right.
the Commonwealth in this case never alleged that this defendant was the shooter.
No, I understand that.
So that's
They alleged that somebody else was the shooter, Brown.
correct.
Did you indict Brown?
I'm sorry.
Yeah, actually, he was found not guilty, Your Honor. As many cases with masked defendants.
Ms. Montori, the piece that I think is most troublesome, and when I was reading the trial judge's memorandum, it just jumped out at me, was the circumstances in which Brady positively identified them. Is there any doubt that what she was doing, and again, I'm not suggesting she was making up an identification, but is there any doubt that what she was doing was going through possibilities once she thought the masked killer was Brown? That's what she was doing, correct?
That's what, when she asked her cousin, after Brown was arrested, his fingerprint is found on the toilet tank. She
Right.
had heard the
Right.
masked individual
But
in the
I'm not
bathroom
suggesting
remove
that Brown-
And then she asked her cousin, who does Brown hang around with?
And she had never suggested, prior to that time, that the unmasked person whom she saw, because wasn't he sent into, she was called into the room because the children were
She was
crying.
actually forced into the room
Right.
because her
Children
children
were
were
crying.
hysterical. And the defendant was standing there.
Right, and so she never makes the identification as she plays the scene back over her mind. Rather, she comes at it, and I'm just asking you whether my understanding is correct, she comes at it once she has a person who's been indicted, and she has every reason to believe that the police have good reasons to indict him. She then sort of cuts the universe and says, I'm not now just thinking about everybody that I might know. In fact, thinking of everybody I might know, I can't identify the unmasked man. But now if I focus just on Brown's acquaintances, different database. Now, in other words, there's a real link between Brown and Brady, correct?
Yes, but that was all put before the jury, as well as Dr. Yarmy's testimony that
But
went
did the jury
on at
know
length.
that there was, did the jury know that somebody else had said that the masked person?
The jury knew that she knew on the day of her mother's funeral that Brown had been arrested, and that she asked her cousin, well, who hangs around with Brown?
But the jury didn't know that the jury didn't know that Brown had been convicted, of course. 'Cause he
Acquitted.
had-
No, he had been acquitted.
The
The jury did not know that,
did not know that.
no.
But the jury didn't know that anybody had said that there was any suggestion that somebody else had done the killing.
Well, the defense attorney did plant that seed. He went into the relationship between Ian Pitter and the victim with Miss Brady. In fact, she described the fact that there had been a falling out, and that as a result of this falling out, the victim, Mr. Pitter, had purchased a gun and kept it under his bed because his relationship with Mr. Rowe had deteriorated to that
Did
extent.
the jury know that Mr. Rowe acted with Mr. Thompson?
There was, the jury didn't know that, no.
Did they know about Mr. Rowe?
What about him? They knew that he was, that the victim and he were at that point enemies.
So they did know about, they did have Mr. Rowe's name.
Yes, they
They
did.
did- they didn't
And
have-
as well, when the police, there were numerous fingerprints found in that apartment, and the police gave a list of possible suspects to match the prints, and one of them was Mr. Rowe. His name was on that list. His print was not found in the apartment.
Nor
but
was the
his name-
defendant's.
Nor was the defendant's, that's correct. But there was, and that comes back to the fact that this is, and there's an affidavit in
And I
the
take it that
Commonwealth-
Mr. Thompson's prints were not.
I don't
taken.
know that he was, there was absolutely no link between
Do we know that
Thompson
Mr.
and this
Thompson's
victim.
Do we know that Mr. Thompson's prints were not found?
I can't make that representation.
Well,
Your
you say
Honor.
there was no link between Mr. Thompson and this victim?
Right.
That's until Mr. Williams told the police that he had heard that Thompson had killed this victim, in essence, with Mr. Rowe, or at Mr. Rowe's behest, and this is a ready inference from the statement, at least for me, in retaliation for a home invasion that supposedly the victim had perpetrated against Mr. Rowe, which had resulted in their falling out.
But again, I mean, that's just speculation upon speculation upon
Well,
speculation.
it's not actually speculation upon speculation. It's a very clear inference from Mr. Williams' statement. Now, whether or not Mr. Williams had firsthand knowledge of that or what his knowledge of it was, I don't know. But even the victim who testified in this case said that the witness in this case, the victim's girlfriend, testified that the person that the victim had the victim's enemy, in essence, or principal enemy, was Mr. Rowe, because they'd had a falling out.
And that was in her statement as well.
Right, and that was before the jury, but nothing about Mr. Thompson and Mr. Rowe doing robberies together, nothing about at least someone in this mix saying that Mr. Thompson was the one who had killed the defendant, or the victim here.
Well, and Mr. Thompson could have been one of the masked men. I mean, that was never...
Was Mr. Thompson ever investigated on the basis of this statement?
There is an affidavit from the lead investigator in the Rowe murder. Mr. Rowe was subsequently murdered by
right.
Mr. Thompson and his associates.
Good
And,
group.
the lead investigator provided an affidavit in support of the Commonwealth's opposition to the motion for new trial that he reviewed all of the documents in the Rowe murder case, and this was the only mention of the Pitter murder. There was no other mention during that investigation.
Well, I guess my question is, was Mr. Williams' statement that Mr. Thompson had committed this crime ever pursued?
Not
By
to
the
my
Commonwealth.
knowledge,
Okay.
because of the...
Because you've already indicted your defendants, right? Why pursue a lead after indictment?
There was just absolutely no link. I mean, they did, the judge allowed defense counsel to get ballistics evidence from the Roe murder.
But that's not the point. The point that the different gun was used in the Roe murder doesn't solve the problem here.
Well,
That's all very interesting. I mean, if it had been the same gun, that would have been wow. That would have been a huge discovery. But it's not the end of the story here.
But the problem is the veracity or the reliability of this
Mr. Williams.
statement.
Right, Mr. Williams, who you had in custody, not you personally.
No.
The Commonwealth had in custody.
No, we didn't. I believe he was in federal custody.
I'm sorry.
He was
He was being interviewed by your police officers
Right.
while in custody, gave a sworn statement. Do you think the police might have asked, and they might have asked this, where did you learn that?
Well, I think
Where did you hear
it's
that?
pretty clear he heard it on the street. And at the end of his statement, he says, I could help you a lot better if I was out of here. So I think,
Sure.
you know,
We know he
his
understood.
motivation is pretty clear as well.
But I'm saying the fact that you say, well, this, he didn't give more detail. Well, it may be that there was not any more detail to be had, but the police were doing the interviewing. That's the only statement we have here is the statement the police got. We don't know if the police asked more questions about, well, from whom did you hear this on the street? Who might you have heard this from?
Well, he certainly didn't have personal knowledge. I think that's clear. But again, it's not even a sworn affidavit in conformance with the rules.
But I mean that really is.
And again, he's, I hate to belabor this, but this defendant was not the shooter. There was absolutely no link between this, except for that one sentence in that one statement. There was no link between this murder and the murder of Wayne
But the
Rowe.
statement is in, that one little statement you're trying to pick out of this is in the context of Rowe and the victim having a falling out, which we know is true, that the falling out related to a home invasion that presumably the victim perpetrated on Rowe, and Thompson and Rowe committed robberies together, and Thompson was the one, he understood or had heard, had killed the victim.
Right.
All of that's part of the package. It's not just one little statement, I heard Thompson did this.
But the veracity of that is suspect as well.
I know.
But wouldn't it, really the statement that
Should be
Thompson-
tested, for sure, but that's the problem. I'm sorry.
The statement that Thompson did the shooting, wasn't that really a statement that Thompson was one of the three people who were there, even assuming it's true? I mean, that doesn't change the fact that there was this unmasked person who the woman has identified to be the defendant.
And it's clear that the unmasked individual was not the shooter. Mm-hmm. We know that. That was never disputed.
Ms. Montori, are you familiar with the Brown trial? I mean, have you read the transcript? I just want to know in broad details what the defense in that case was.
I believe his defense was that he had been in the he had an explanation of why his fingerprint appeared on that toilet tank, that he had been in the house previously. There was an explanation for it. And because he was masked and never removed that mask, he was found not guilty.
Of the four African-American men who were brought shortly after the killing, was one of them the defendant?
No. No.
How many men were there on the scene? 3 or 4?
3. There were 2
Okay.
masked, and the defendant was unmasked. And it was pretty clear from the evidence that he attempted to avoid Miss Brady because the first person who entered was masked, and he pushed her head down, and all she saw were 2 sets of other feet go by. This defendant went into the kid's bedroom, and the other masked man went elsewhere in the house.
They were looking for money or drugs, correct?
Appeared money. And in fact, she testified that they took money. And it appeared, though, that he was not expecting to see her. He put himself in the bedroom with the children. She was bound, her eyes were taped, and because it was sort of an impulsive move, I think, on the part of the person who was pushing her around, the masked man who was pushing her around, to have her stick her head in that room to tell her children to be quiet. And that's when she saw the defendant, who was standing near the door.
How did she see him if her eyes were bound?
I'm sorry, her
mouth.
mouth was bound, and they removed the tape.
I'm looking at your brief, and again, please understand that this woman is terrified, not only for herself but for her children, and so who knows, right? But this is at least what the evidence is, and that the defendant was the father of her cousin's child, that she'd seen him approximately a year earlier, that she had gone to junior high with him, and they both grew up on Blackburn Circle. I think that you can hear from the court's inquiries that what is confusing here, and I haven't read the identification testimony, is she was terrified at the time. What is it that triggers her now identifying this person who she appears to have known quite well? She had not seen him for a year, but she went to junior high. I mean, she had no problem knowing him from junior high, from Blackburn Circle. Is only when Brown, subsequently acquitted, narrows her scope, and not only narrows her scope, just who does she know? She says to the cousin, one of these 5. He gives her 5 names. So she goes through those 5 names in her mind. And she has a light-skinned, between the ages, I think, of 18 and 23, or 28 and 33, I mean, I forget the ages of the identification of the defendant, and she says, well, it's not A, can dismiss that, I don't know why, not B, not C, yes, it is D, and not E. I mean, she really takes what she's been thinking about for a very long period of time and reduces it to 5 names that she hasn't thought of.
Sure, and that was, the suggestibility was certainly before the jury. If you read the defense counsel's closing, I mean, her lack of credibility is the clear focus. I believe the expert witness testified as to suggestibility and how that plays into identification as well. So that was before the jury. And again, all of her problems with this identification were put fully before the jury. But again, there's no link between
Can I ask you, this was
Thompson
Brown's
this case.
fingerprint, but before, was it clear to the jury that, it must have been, that Brown had been indicted for the murder?
Oh, yes.
And his fingerprints were found in the
Yes.
place?
Yes. The cases talk about substantial even to get in hearsay, there has to be a substantial connecting link
Well, what
between
I think
the third party and this crime, and there just isn't.
I think if you listen to what Mr. Curhan was saying this morning, I think what he is looking for, I think he understands there's not enough here to get a new trial. What he's looking for is an opportunity to take some additional discovery as a result of this report, and then to sort of repetition or provide a supplemental petition for a new trial and seek a hearing on it.
I take it that other than Brady's testimony, and again, I haven't read the transcript, that the evidence against the defendant was a statement made while incarcerated with some other people?
Yes.
There was no other evidence?
There was no other evidence, no other direct evidence, no. No
Was any-
other
was-
real circumstantial evidence either. There was no fingerprint or any kind of biological evidence found at the scene as well. But I think that the defendant just doesn't reach any threshold of getting additional discovery in this case, again, because this
Well, he's
totem
over
pole
the
hearsay
newly
statement.
discovered. He's over the newly discovered. I have a footnote from the judge saying this is newly discovered. Usually we hear arguing, as we were in the earlier case, is it newly discovered? Here we over the hurdle of newly discovered. So the question then is, are you into the second prong?
But it's not exculpatory, and even if it's exculpatory, how is it admissible? How is it ever going to lead to admissible evidence?
Well, the Commonwealth has an obligation to turn over exculpatory evidence, even if it's not admissible. If they have reason to believe or they have evidence that someone else committed the crime, that evidence may be the result of hearsay. That doesn't somehow make it something you don't have to turn over.
But this defendant wasn't the shooter, as the judge found as well.
No, but nobody claimed that. I think, again, what's complicating it here is that, we have lots of situations where somebody says X did it, and there's absolutely no connection. Unfortunately, here we have a real connection, as Mr. Cohan points out. The one is, I heard it on the street, but the other is, these people work together. And you're telling me that the jury knew that there was some connection between the victim and Roe.
Right, and the defense counsel knew that, and my guess is he probably investigated it, and
in fact sought information about the Roe murder investigation.
I mean, there were other people who...
And it was not turned over. I mean, that's part of the problem here. Yes, defense counsel clearly was tied into the fact that Roe had a motive here, sought information from the Roe murder investigation. The Commonwealth objected and was able to limit the judge to just providing the ballistics, which, as I say, could have been a home run, but the fact that they didn't match up doesn't really say much.
Well, but there's nothing. I mean,
there's a statement from Thompson, who was interviewed in the Roe murder investigation, that someone else did this murder and a motive for it. Now, you may say, well, that's hearsay and whatever.
It's not a statement from Thompson. It's a statement from...
Williams. A statement from Williams, right, who was a drug dealer, right,
Well,
as all of these were, in this area at the time, who obviously knew Roe and Thompson.
Well, I think that's... He knew who they were. But I think, there are a lot of cases where if you speculate enough, you can say that, well, these two murders are somehow related. That would happen in a lot of cases where drugs are involved or things like that.
You say counsel knew about Roe. Yes, he did know, because the Commonwealth turned over information that Roe was an adversary. But when he attempted to learn more information about the Roe murder, which followed right on the heels of the murder here, he was denied that information. And as it turns out, subsequently, after his trial, there's at least something in that file that certainly could have been used by the defendant to conduct further investigation precisely on that point. That's the problem. That's, at least as I see it, that's the problem.
Thank you, Ms. Montour.
Thank you very much.
All right. Hear ye, hear ye. All persons having anything further to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting across from within before the Commonwealth, and present to part, the sitting of this court is now adjourned. God save the Commonwealth.